Thanks everyone for joining us for today's webinar from the Institute for Research on Poverty. I'm Dave Chancellor and I'll be your host today. The title of our webinar is Monetary Sanctions Using Fines and Fees to Punish the Poor. And I'm very happy to welcome our presenter, Alexis Harris, who's a professor of sociology at the University of Washington and also an affiliate of the Institute for Research on Poverty. So Professor Harris's presentation is going to draw on work from her book, A Pound of Flesh, which was published last year by the Russell Sage Press. We're really fortunate to have Professor Harris talking with us today. She's among the foremost experts on this issue of criminal justice, fines and fees, and other forms of monetary sanctions. But you don't have to take my word for it. Just yesterday, Chris Eugen at the University of Minnesota tweeted out this endorsement of Professor Harris, which I promptly screen grabbed and pasted into the PowerPoint here. But a couple of quick notes before we get rolling today. First, I want you to take note of the Q&A box at the bottom of your screen. You can type questions in there throughout the webinar, and we'll get to those, as many of those as we can, in the last 10 or 15 minutes today. And second, we are recording today's webinar, and so we will have that probably posted on the IRP website and on our YouTube channel by Friday of this week, maybe a little bit earlier, but definitely by Friday, so you can look for it there. And if you did indicate that you wanted to have that link sent to you when you registered, we'll also be sending that out as well. So with that, Professor Harris, thanks so much for being here. I'm going to turn it over to you now.
Great. Thank you so much. Thank you to the Institute for Research on Poverty at the University of Wisconsin, the other UW, for this opportunity to share my research. And thank you to the audience for spending an hour of your summer with me. And lastly, thank you, Dave Chancellor, for helping me prepare and set up these slides. I really appreciate this. You made it real easy to share my research. So I will be talking today about monetary sanctions, and for many of you, you probably know what these are, but I define them as illegal financial obligations, or I also call them LFOs. I'll define them a bit at the beginning of the outset of my talk so we're all on the same page, and then I will outline my book, A Pound of Flesh, and talk about my research questions, the data and methods used, and then dig into some examples of monetary sanctions. And these, I want to highlight ones that aren't commonly described in our discourse, but highlight the ones that in particular differentially impact poor people who make contact with the criminal justice system. And then I'll talk a bit about the punishment continuum, the findings from my book that show how different jurisdictions, counties, differently apply and enforce one state statute that governs the monetary sanctions within one state, and that's Washington State. And then provide a summary of implications for policy and research, talk a bit about my current research project, and still outstanding questions. So to define the issue of monetary sanctions or legal financial obligations, there are a host of financial penalties that are imposed on people who make contact with our systems of justice. Fines are fixed financial penalties attached to conviction for any given offense. So for example, in Washington, a first-time drug conviction can result in a $1,000 sentence, with each subsequent drug conviction being $2,000 per charge. The maximum fine per felony conviction ranges widely across the states. In Massachusetts, for example, defendants convicted of a felony can be fined $500. In Arkansas, Class A and B felonies carry a fine of up to $15,000. Defendants found guilty of murder, attempted murder, or sexual assault in Alaska and drug crimes in Kansas can be fined up to $500,000. In many jurisdictions, the maximum fine does not include other monetary sanctions. And it's important to note that the fines, at least in statute, are intended to be an additional punishment. So in addition to jail or treatment, probation, electronic home monitoring, work release, the fines are viewed as a punishment for an offense that was committed. But in addition to fines, people are charged fees. They're charged for the costs of using the justice system. These user fees include the cost of a public defender, court costs, including paperwork and filing fees, probation supervision fees, and even incarceration costs can be imposed upon people convicted at the time of sentencing. So some examples, in Louisiana, they have a judicial expense fund, and that cost is $300 per conviction. In North Carolina, they have a cost of justice fee that's $154.50 per conviction. Illinois has a filing fee of $190, and they can charge for a public defender of up to $5,000. Arkansas charges for a public defender between $10 and $100, and several states charge for the cost of the blood extraction for a DNA analysis. So that's $200 in Illinois, $250 in Texas, and $100 in Washington. So we have fines, we have the user fees, we have surcharges for court and non-court related costs. And these are costs levied on top of the fines and fees. Sometimes it can be a set amount, a $100 surcharge or a $200 surcharge. In certain states, there's just a percentage of all financial penalties is assessed. So in Arizona, for example, there's an 83% surcharge, 83%. So if I'm charged $1,000, I'm charged an additional $830 for this surcharge. And there are different funds that the money goes to. So 47% of that surcharge goes to the Criminal Justice Enhancement Fund. 13% goes to Medical Services Enhancement. 10% goes to Clean Elections Fund, which is actually a pot of money for people who are running for local elections. 7% goes to Fill the Gap Fund, and 6% goes to DNA costs. So those are surcharges. And it's important to note that some of these additional charges aren't even related to criminal justice processes. They're unrelated, essentially, to the charge that the person's being convicted of. In addition to surcharges, there are collection costs and interest on unpaid balances. Some scholars and policy advocates have referred to these as poverty penalties that disproportionately target people who are unable to fully pay off their imposed fines and fees. So if you can't pay your bill at sentencing, then you will be charged additional costs, and that's in the form of collection costs and interest. In Florida, there's a 4.75% interest. In Georgia, 7%. In Washington, we have a 12% interest cost. In Illinois, 15% on unpaid, and then there's a 30% collections fee. And Arizona has a 19% collections fee for delinquency and a $35 fee for not paying your initial fines and fees. In addition to the fines, the user fees, the surcharges, the collection costs, then there's restitution. And restitution comes in two forms. One, there's direct restitution directly owed to the victim, say for car insurance or medical bills. And the court will charge you the restitution. You pay the court clerk, and the clerk then dispenses a check to the victim. There's also restitution costs that will go to a local fund that supports victims. In Washington, we have a $500 victim penalty assessment that's charged per felony conviction, and it provides resources to prosecutors' offices to support victims. So this is the issue I will be talking about today, the system of monetary sanctions in the United States and how they operate across states and within states. I want to note that there are many layers of legal debt. My book focuses strictly on felony monetary sanctions, so superior court convictions, but I'm assuming, many of us have faced monetary sanctions in the form of traffic tickets or misdemeanor court fines. And you'll be surprised that when you pay that traffic ticket, the bulk of the ticket is actually not the fine, the punishment for the crime, but it's the user fee and the processing fee that's attached to that traffic ticket. There are also juvenile monetary sanctions. Children are sentenced to fines, fees, and restitution. They're charged for court services, placement and out-of-home placement costs, probation, drug testing and treatment, psychiatric treatment they're charged for. Parents are responsible to make these payments. District court, lower court monetary sanctions as well, felony monetary sanctions, which I studied, and then federal monetary sanctions. So there are a host of layers of fines and fees, and as we know, if you work or are a practitioner or an advocate for people who are criminal justice involved, you know that many times there are multiple points of involvement in the systems of justice, and so people have multiple layers of debt. I'd like to turn to talking briefly about my book and some of the research that I found in Washington State. Firstly, my questions that I asked going into the study of this process is, how does the criminal justice system impose monetary sanctions? What are the specific policies, practices, and mechanisms used within the criminal justice system to impose this sentencing option? So how does it work? What are the guidelines of this system? How do policymakers and practitioners define, interpret, and apply policies within the institution that allow the criminal justice system to act as a social stratifying system? And what is the relationship to poverty and marginalization? There's a host of sociological work that describes the social and legal consequences of mass conviction and incarceration and offers frameworks for understanding this phenomenon. So we know, for example, that post-conviction, what happens in terms of employment or voting rights, but what happens within the institution itself to produce and possibly reinforce inequality? Can it be that there's the system itself, not just the collateral consequences that lead to inequality, but the very system of justice that creates and maintains inequality as part of its everyday sort of workings? In terms of data for this project, I looked at Washington State automated court data. I had a sample that I looked at. I did interviews with court officials, any court officials that would be willing to talk with me. So I talked with people who owe debt. I talked with judges and clerks and prosecutors, defense attorneys, and even a handful of state representatives. I did observations of sentencing hearings of when monetary sanctions are imposed, and also sanctioning hearings. So what happens when someone comes to court and says, I don't have the ability to make payment? What does the judge do in those circumstances? I provide in the book a summary review of national state monetary sanctions and a detailed review of Washington State statute. I narrowed in specifically for the study on Superior Court, so felony fines and fees imposed at sentencing. I performed a statistical analysis of the Washington State automated court data in the book, a qualitative data analysis of interviews and observations. I selected 5 counties in Washington State to focus on, and I collected field notes of my observations and interview transcripts, and I did open and closed coding with in vivo. I charted the relationships between the key concepts and developed typologies. I created analytic memos on key themes and developed the chapters in the book around these themes. I also located and read and watched a lot of these debates around legal financial obligation or LFO-related statutes were online. I was really interested in the politics around the creation of these statutes and what were the different arguments for and against the statutes. And then I did a national review of the state statutes, and it wasn't comprehensive in any way of all state statutes, but I provide examples in every state of statutes governing fines and fees. Now I'd like to move into talking about a couple buckets, if you will, of fines and fees that are charged to individuals, but some of which that we don't commonly think about. There are several ways in which people who make contact with the criminal justice system are charged for their contact. Actually, I'm missing one. I just noted it this morning. I'm missing one box that should be here, and that would be one on asset forfeiture. And there was actually today just a memo released by the Department of Justice, Trump's Department of Justice, on asset forfeiture. So it would be important to add a box on that. But the first contact with the criminal justice system, oftentimes people are facing bail, monetary money bail. Then they're charged public defender costs, conviction, fines, fees, restitution, and surcharges once they're convicted, and then collection costs, interest, collection fee, late payment fee. Payment costs, something that we don't often talk about, and I'll talk about this in just a minute, but it costs to make each payment for people who are making payments. There are also incarceration-related costs. We've seen multiple stories and investigations on the high costs of phone calls, collect phone calls to family members of incarcerated people. It costs to see the doctor at the dentist to get prescriptions. It costs to, money is withdrawn from inmate accounts when family members make contributions. There are housing fees. People are charged daily rates or can be charged daily rates per jail or prison stay. And then there are current research, my colleagues have noted that people have write-ups while incarcerated, and they can be charged $25 per write-up if something is askew in their cell or they're found to be doing something wrong. There are probation costs, supervision fee. It costs to be supervised. You have a monthly payment, and that can be for a private or paid to the state, or it can be also a private firms can manage, as they were doing in Georgia. There are regular urinalysis tests that you're charged for. There's also a host of charges for alternative sentences, so victim panel classes that you're mandated to attend, drug and alcohol treatment and assessment. If you're sentenced to these types of alternative sentences in the community, you have to go and pay for that treatment. And in Washington, it can cost $3,000 to $5,000 for treatment. You're charged for work release, a monthly fee to be in work release, and you're also charged for electronic home monitoring. So there's a host of other monetary penalties that people pay when they make contact with the criminal justice system. I focus again on the book on conviction, collection costs, and payment costs that are imposed to individuals. What did the court order as a sentence to people convicted of offenses, and then what were the collection costs related to the sentence legal financial obligation? And in particular, I'm interested in how did these extra costs accumulate for poor people who encountered the court. So one example that I want to talk about is paying for a defense attorney. I'm going to give 3 examples of costs that we might not usually think about. So the first is paying for a defense attorney, and this is the one that's appointed to you if you can't afford one. 71% of the states that I analyzed for the book can legally charge indigent defendants for their court-appointed defenders. In certain Washington state counties, for example, indigent defendants are required to pay indigent application fees ranging from $10 to $25. So even before you get appointed an attorney, you're charged to have a review process to determine if you're eligible for a public defender. People are required to sign promissory notes. In 2007, for example, the felony promissory note fees included 6 monthly payments of $226.11. So 6 payments of $226.11 for the attorney that you can't afford. If the person cannot pay the fee up front, then the amount is added to the judgment and sentence upon conviction. Based on the revised Code of Washington, those determined, quote, indigent but able to contribute, end of quote, will establish a payment schedule and pay a monthly amount to the court during their adjudication. So you can see the costs range across different states. The application fees for eligibility determination in Louisiana is $40. People can also be charged in different states the related cost of counsel, whatever sort of that is deemed to include. You can be charged your actual attorney costs in certain states with some caps. And in Ohio even charges the cost of prosecution. And so that would be the cost of those attorneys and witnesses that they bring. One big question that people commonly ask is, why are poor people charged for the public defender? Put this up here. There are several legal cases that establish this practice. Gideon v. Wainwright established that in 1963 that the assistance of counsel is a fundamental right in a criminal trial. Miranda v. Arizona in 1966 found that when arrested, people must be warned of their Fifth Amendment right not to be compelled to incriminate themselves. From this, local jurisdictions developed their own set of required Miranda rights. Different police forces actually created different wording of what they considered your Miranda rights. And some of them, and not many of them are online, but I've searched across different states and looked at the differences, and many included the mention of the right to counsel if you cannot afford one. A few that I found said that you won't have to pay, but in many jurisdictions it just says you have the right to counsel if you can't afford one. It doesn't say that doesn't mean that you won't have to pay for them. Fuller v. Oregon challenged the imposition of costs and the Supreme Court found that there were actually adequate protections, particularly in the Oregon statute. It determined that the Oregon law did not infringe upon defendants' right to counsel, since the knowledge that defendants may ultimately have to repay the cost of legal services does not affect their ability to obtain such services at the outset of and during the case. So knowing that they're going to have to pay doesn't affect their representation. The court found that the requirement of payment is never mandatory. Thus, charging indigent defendants for the cost of their public defense is both a legal and common practice nationally. Nowhere in these opinions is a clarification of the appointed counsel, who will pay that appointed counsel, and the state is not required to pay. Another example of payment costs are the per payment costs that I mentioned earlier. And this I took from one of the counties I studied online. I call it Warrant County as a pseudonym. It says, online payments can be made securely with your credit card or debit card at the following warning, and they give a link. There's a convenience fee of 3.5% or a minimum fee of $1 per transaction, and you will need your case number. You can pay by phone with a credit card, and again, you're charged that convenience fee. It notes, which is really interesting, that failure to make monthly payments may result in your being cited into court on a specified date with the possibility of a jail sanction. Also, a bench warrant may be issued if you fail to appear in court. And this court was known for regularly issuing bench warrants for non-payment on fees, not just restitution, but on fines and fees. So I definitely want to raise attention to how not only are these costs imposed on people, but if you're poor, it costs even more to make your minimum monthly payment. Thirdly, here's an example of how the debt can increase for people. This is an amortization table of LFO assessment. This is the average amount in Washington State in 2008, $1,347. And it's analyzed with 12% simple interest. So interest does not accrue on interest, but only accrues on the penalty. It also includes a $100 annual surcharge that's charged for any open account. And so you can see that if you make a $100 monthly minimum payment, you can pay off that average debt in 2 years. However, as we know, and many of the people I interviewed don't have an extra $100 a month, and so they get caught in the cycle of making the minimum monthly payments. The average amount of payment that people made of the people I interviewed was $31.25. And so you can see that even after 5 years of making that minimum payment, people still owe $256. And I want to highlight, and this is also from my book, that this is a common practice. This isn't happening in Washington State. As I'm sure many of you know in the jurisdictions that you live in, that fines and fees and the system of monetary sanction is a national practice. 100% of the states have statutes that allow for fines and fees to be sentenced to felons. 69% impose what many call these poverty penalties, additional charges for being unable to pay it off. 71% charge for a public attorney, 92% can charge for incarceration for non-payment, 77% charge or allow for community service provision. So they allow the courts to translate the dollar amount into community service hours, which leads to a host of other problems that I won't address here. And in 42%, only 42% debtors of the states can debtors vote. In Washington State, we have a provisional right to vote, that if you're making regular payments, however, if you miss 4 payments, then the prosecutor can petition the court to withdraw your right to vote. I'll turn to talking a bit now about how the system of monetary sanctions varies across jurisdictions. So we have this whole family of fines and fees at different layers that can be assessed, but I found in Washington, and we're finding in other states currently, that the degree to which it's imposed and the ways in which it's imposed and the way that people are punished or monitored for non-payment varies a great deal. I want to focus on 2 points of this process of the system of monetary sanctions. One point that's key is sentencing, and this is the time at which criminal defendants are sentenced to jail time, prison time, all the other sentences they receive, and their financial penalty. What I found through observations and interviews is that there is a lack of assessment of the current ability to pay at the time of sentencing. Many times judges would just assess the routine amounts of fines and fees, the regular $450 for a public defender, $100 collection cost, $100 DNA, those sorts of things. And there would be no discussion of what type of income the defendant has. Many times there would be a reliance on this notion, and this is written into the statute, future ability to pay. Everyone before the court was commonly assessed as maybe having a future ability to pay, and that's why we would give them the regular fines and fees. Who knows if they're going to hit the lottery? Who knows if they're going to get a settlement? We might as well sentence them to this and to see if they might have the future ability to make payment. That's literally what people told me in interviews. And then there was a lack of judicial understanding or agreement or policy guiding the assessment of indigence. No one talks about indigence in open court when assessing the fines and fees to individuals. So that's sentencing. There's a second step that's key is the determination of willful nonpayment, is the assessment of when somebody does not make a payment, they're summoned to court, and then there's this discussion of noncompliance and why. Some jurisdictions, while I was doing the research, weren't holding hearings at all, and there was an auto jail policy in one of my counties that's since ended, where people would just automatically go to jail. Automatically, you don't stop, you just go straight to jail. Many people do not have attorneys present at the hearings if the hearings are held. There's assessment of available income for payments. Includes examination of conspicuous spending, government subsidies, and other unreasonable notions of employment. For example, one prosecutor suggested that he tells people before the court to go stand by the side of the road and beg for money to raise money. So just unreasonable notions of how people are supposed to secure money for their payments. So what I found is that there's this varied system. What emerges is a varied county-level orientation towards the system of monetary sanctions. When I first set out to conduct observations and interviews in the 5 selected counties in Washington, I assumed that there would be some differences in legal financial obligations, the sentencing and the process, given that my colleagues and I had found statistical differences across the counties in Washington. But I thought that in general, some coherent and consistent set of practices would exist across all the counties, right? I was naive. I thought, well, at least there's one state statute and everyone has a certain common sense of principles and practices, but I was completely wrong. In fact, what I found is that within each county, the court actors thought about monetary sanctions very differently. And in a related way, they used their discretion at key decision points in different ways. What's more, the resulting policies and practices for assessment, collection, and the sanctioning of non-payers all differed. It was very surprising to see such differences in the interpretation, application, and consequences of the exact same statute. One of the primary conceptions court actors used when discussing the process of monetary sanctions was the image of who they thought the defendants were. And these are judges, prosecutors, and clerks primarily who I'm talking about. Consistent with prior research on courtroom decision makers, notions of defendants' moral character. So what type of person is this? Essentially, the decision maker would ask about the defendant. It drove much of the decision-making processes, and so court actors applied a well-defined set of ideas about the character or the behavior of so-called typical defendants processed in their courts. Across the counties, a range of characterizations were made, including descriptions of poor and marginalized people, people of color, people who were undereducated and unemployed, chemically addicted people. Some even viewed the people as being malicious or criminally minded, even lazy and unaccountable. So a significant difference in how court actors talked about defendants was the differentiation between the structural problems and positions. So some people talked about structural problems leading to why the defendant was before the court, and they were a little more understanding of non-payment, while others focused on these assumptions about negative lifestyles and poor character, and that led to a very different orientation of the court to those people who were labeled that way. Secondly, there's a strong notion of accountability. Everyone uses the word accountable. That person has to be held accountable. Are defendants exhibiting remorse for their criminal behavior? And so, interestingly, the monetary sanctions were viewed by court actors as another means to hold them accountable. So in addition to going to jail and to prison and probation and everything else that they were asked to do or mandated to do, making payments was key for people to show their monthly remorse. So, for example, courts have different orientations toward the use of incarceration for non-payers. So some courts would regularly incarcerate, others weren't. Non-payment in some courts would lead to arrest and incarceration. However, in some counties, people in power only used incarceration as a tool for those who they could identify as not paying their restitution but clearly had stable incomes. So the path to incarceration is twofold. One, you don't make your payment, you're sentenced to the payment, you don't make your payment, you're summoned to court, so you have to have a physical address and not be homeless to receive that court summons to know that you're supposed to go to court. If you don't respond, a warrant can be issued, and then if you make contact with the police, arrest and incarceration occurs. So that's the step one of incarceration. The second step of incarceration is after you're incarcerated, you're eventually brought before the court for a hearing to determine whether or not or why you violated or to substantiate that you did violate the court order of non-payment and then receive a punishment for that. And many counties that I looked at, courts would issue an additional 10 to 60 days of incarceration for willfully violating your court order that mandated you to make payments. So that's sort of the path to different steps of incarceration for individuals who are unable to make payment. One big question that people always have is legally, how can poor people be incarcerated? The legal concept of willful non-payers is key. That judges will try to assess whether someone willfully made a non-payment or willfully failed to make a payment. And it's viewed as a violation of your court orders. The monetary sanction was your sentence. You didn't make your sentence, so you violated your court orders. Or you're found in contempt of court for not paying. Incarceration is allowed as a punishment and not a new sentence. So in Arizona, you can be incarcerated until the payment is made. In Kentucky, it can be up for 60 days. In Alabama, it ranges from 10 days hard labor to 30-plus days. The vast majority of states, 92%, allow for the incarceration of non-paying debtors, and only 4% had clear language that did not allow for their incarceration. So debtors' prisons are legal. A lot of times you see these articles that they are not legal anymore. But they are. In 1931, states began abolishing the use of prisons for people unable to pay their debt. So this was a legislative action where states said that we will not incarcerate people who cannot owe civil debt, who cannot pay civil debt. In 1970, it was determined that legal debtors can be held in contempt of court, but they can only be imprisoned for a time fixed by statute for an offense. But they can be imprisoned. Tate v. Short found that incarceration is permitted if a person can be labeled as a willful non-payer. You can convert fines to jail sentence due to indigence, but you need to determine the ability of someone to pay. And then Bearden v. Georgia established a precedent for willfulness. So it established the willful concept, and it said that people need to be able to show that they made sufficient bona fide efforts to make the payment. So they went as Bearden did, mowed lawns, or they did some type of work, or they tried to get loans from family members. So by Bearden v. Georgia, the sentencing court must find that defendants willfully refuse to pay or fail to make sufficient efforts to acquire the resources. The big problem, though, today is that courts are interpreting indigence and bona fide efforts as willful non-payment. So, for example, some judges explore defendants spending on conspicuous spending or use of their limited money on what judges assume for unnecessary purchases. And this quote here was during an observation of a court hearing where the judge was asking this person I call Leslie why she didn't make a payment. And Leslie explained she used her discretionary money to pay for her court-mandated drug and alcohol classes. Instead of acknowledging her limited fiscal circumstances and compliance in paying for her classes, the judge interrogates her about her tattoos. The judge was solely focused on why she did not make her LSO payments. The judge asked, "How many tattoos do you have?" She replied, I think she knew what he was going after. She replied, "I have my son and brother as tattoos." The judge asked, "How much did they cost?" She replied, "I didn't pay anything. My friend does them for me." The judge asked again, "You didn't pay anything?" And she shook her head no. Other judges that I observed and during interviews said that they would ask about spending on cigarettes and tattoos and manicures and try to look for any evidence was spent on items and not on LFOs. Some judges would assess defendants as not in compliance and willfully not paying their court fines and fees solely because they smoked cigarettes or got tattoos instead of making payments. So to move forward with a summary, there are multiple dimensions of monetary sanctions. I think I've made that pretty clear. And the layers of the legal debt keep poor people tethered to the criminal justice system in a very, very different way than criminal justice involved people with means, with financial means. State and local statutes and case law are extremely vague and allow for a great deal of discretion for not only judges but for clerks who manage the court debt. There are various informal practices that lead to incarceration that aren't documented. We lack systematic evidence that allows us to examine potential disparities, and we lack systematic evidence demonstrating monetary sanctions are cost-effective. In the final chapter of my book, I like to note that I resume a broader analytic lens to consider the implications of the system of punishment for the United States process of social stratification and inequality. I discuss the broader theoretical, substantive, and policy implications of the reliance of monetary sanctions in an era of mass conviction and incarceration. I just want to note here that I don't treat monetary sanctions as a collateral consequence as the result of court convictions. Rather, they are a purposeful sentence that have created a two-tiered system of justice, one for the poor and one for the wealthy. Poor people, because of their inability to post bail, to pay their fines and fees and restitution, have more expensive experiences with the criminal justice system via interest, collection costs, and fees for payment plans. And they also face more incarcerative time than wealthy people because they are poor. So if you can't pay bail, you're going to sit behind bars and wait. And just because a person pays $5,000 bail doesn't mean that they're less violent than a person who doesn't have $5,000 to make that bail payment. So the implications for policy, there are several, and there are several different alternatives to protect poor people who make contact with the criminal justice system. I'll just go through really briefly. One of them is a credit system. One judge that I spoke with said he sentences the normal costs of fines and fees in Washington State, but gives money credit for someone getting their GED. So they'll get $1,000 credit towards their debt if they get their GED. Along similar lines, courts could follow his lead and give credit for completion of work training courses, regularly attending NA or AA meetings. There's a host of sort of a schedule that you could create where people get credit. I mean, I think in this notion of accountability, if you know you're not going to get the money, then why not give credit for the person at least trying to be responsible and change their life? Day fines in many other jurisdictions outside the U.S. Impose fines, but they are in lieu of incarceration, and they're done with a consideration of defendants' abilities to pay. They literally have a number associated with the offense and calculate the person's daily wage and multiply that number for a fiscal sentence. So the sentence is then proportionate to the offense. So all people have the same, who are convicted of the same offense have the same number. But it's also proportionate to what the person makes for a living. So what I'm charged for is proportionate to what I can pay, but also the offense compared to what Bill Gates, who lives across the way from me, pays. States also need to establish a clear indigent statute that must be applied during the assessment of ability to pay in sentencing fines and fees. They should have clear guidelines for judges to determine whether or not a person before the court is poor or indigent. Ironically, in Washington, we have a state statute with a definition of indigence, but it's not applied or mandated to be applied at the assessment of fines and fees. It includes whether or not the person is currently receiving assistance under a needs-based, means-tested assistance program. So for TANF, we have GAU, GAX, SSI, Veterans Benefits, food stamps programs. So if people are receiving these federal benefits, they should be deemed indigent and unable to pay. Other states are moving towards bench cards, which basically tells judges what the law is, and many judges aren't aware of the law in their state. And so the bench cards help judges with that. Ohio and Washington took the lead with bench cards, but there's also been a national bench card that was issued by the National Center for State Courts. Establishing court rules for individualized assessment of indigence would be helpful during these hearings. But much of these changes need to come in the form of legislative statute changes. We need state legislatures to start thinking about how poor people are differentially treated and processed in our systems of justice. Briefly, I want to highlight some of the current research that I'm doing. This project is funded by the Laura and John Arnold Foundation. It's a multi-state study. We have 8 states in the study, and it's a 5-year study. You can see the states here: California, Georgia, Illinois, Minnesota, Missouri, New York, Texas, and Washington State. And these are my great collaborators, leading scholars in sociology and criminal justice that are examining the systems of monetary sanctions within their states, and we'll be doing within our state analysis and then across the states. The project goal is to encourage a national dialogue around the sentencing of monetary sanctions and generate a data set and policy briefs that allow for within the multi-state analysis of the system of monetary sanctions. I want to highlight some of the things that we're doing. One thing is a policy review, and that's available now of the 8 states at monetarysanctions.org. We're doing interviews with people, basically replicating and expanding what I did in Washington, observations, and we'll have state-level automated court data. The timeline is we're just finishing year 2 doing court observations and interviews with debtors. We should have a report released soon on those interviews, hopefully in the next couple of months. I'm sort of speeding up the time because I want to be able to address questions. But there's 6 key findings of the policy review. The legal financial obligations are routinely imposed. Unpaid legal financial obligations can trigger additional sanctions that vary in scope and severity. State sanctions stipulate the imposition and enforcement of legal financial obligations, so this is a mandated practice by the state. The key aspects of the imposition and enforcement of legal financial obligations vary across the states and within the states. So, for example, this is a chart from the first report that we issued, and you can see how the justice costs, for example, driving with a suspended driver's license, vary across states. California, it ranges from $300 to $1,000. In New York, $200 to $500. And it's interesting that you can see how the cost, with additional fees and surcharges and added charges, what the amount is actually due. And this is calculated if people made $50 monthly payments, how many months it would take to actually pay those fines and fees off. So here, the red circle shows you. If you look at the fines, and then you can see the amount due at sentencing. So the last 2 key findings were that legal financial obligations create a range of stakeholders, which is really key for thinking about everyone who needs to be at the table, for thinking about the consequences of these policies, and also how can we change the policies to protect people who without financial means who come before the court. And there are active legal challenges to legal financial obligations going on. So it's a very active research field right now. There's several unanswered questions that are still outstanding. A lot of them are around economics of the system. How much is spent on monitoring, collecting, and sanctioning people? What, in terms of public collection units, we've created a new apparatus of the criminal justice system in itself to collect these fines and fees. How much does that cost, right? And is it really worthwhile given the incarceration costs? Also, how much is recouped? What is really coming in? There's no one data set that really helps us understand how much money is coming in from this and how much unanswered, how much outstanding debt exists. How is the money reallocated? Who's really getting the money? Is it going back to the counties? Are victims getting their money? And a key question is, to what extent are communities of color disproportionately incarcerated because of their inability to pay court fines and fees? And just a side note, I think most of us are well aware of the consequences of mass conviction and incarceration. We have over 2.25 million people living behind bars. We have over 7 million people in criminal justice supervision. This growth in conviction and incarceration and other types of punishments is occurring in a disproportionate way, where people of color are vastly overrepresented at every stage in the criminal justice processing, from arrest, prosecution, conviction, and sentencing. So, for example, while 1 in 87 working-aged white man is living behind bars or in prison and jail, 1 in 36 Latino men is living in jail, and 1 in 12 African-American men lives behind bars. 1 in 12 African-American men lives behind bars. 2/3, and we also know a great deal about the poverty of people who face the criminal justice system. 2/3 of people have annual incomes under $12,000 prior to the year prior to their arrest. So 2/3 of people have under $12,000 annual income, and the average fine and fee in Washington without restitution was $1,300. Right? The risk of incarceration for white men is 1%, 3% for Latinos, 10% for black men. So my great colleague Becky Pettit and Bruce Western have found, quote, prison time has become a normal life event for African American men who have dropped out of high school. A normal life event is prison for African American men. So with this dramatic overrepresentation of people of color and poor people in the criminal justice system, we can surmise that the system of monetary sanctions disproportionately affects people of color. And we have to start talking about this. Given that, this brings me to the national discourse on fines and fees, and much of it is related to racial disparity and inequality. I'd be remiss if I didn't mention a lot of media attention from, Joe Shapiro in 2014 had an NPR series highlighting the problems that poor people face. There's been local NPR stories across the states, and LA Times, New York Times had op-eds. There's been national discussions and reports. Art City Public Defenders did a report in 2014 on Ferguson. The Obama DOJ had a Ferguson report as well, looking at the disparities in fines and fees, particularly the police using fines and fees to over-police African Americans in Ferguson. Obama's Department of Justice had a convening. And there was a convening at the White House in December 15, just on the topic of bail, fines and fees reform. The Obama DOJ wrote a Dear Colleague letter to judges nationally, and it outlined a set of basic constitutional principles, reminding judicial colleagues of how to better protect the rights of poor people in their courtrooms. I'd like to note really quickly that the National Center for State Courts just issued yesterday a 2017 Trends in State Courts that focus on fines, fees, and bail practices, challenges, and opportunities. It's at ncsc.org, National Center for State Courts. ncsc.org has a great report on fines and fees. There's a national task force that's working on fines and fees as well, and the U.S. Commission on Civil Rights have had both national and within state conversations too. So there's a great deal of conversation. The big problem is that we still have challenges to make a fair system. So lots of the problems are state budgets, that there's this assumption that they rely on fines and fees. There's this notion of a need for extra punishment, that people still need to be punished more and more and more, and it's part of the system of accountability. How do we hold them, whatever accountability means, how do we hold them accountable? We need alternatives. We need alternative funding models. We need local policies and practices for the criminal justice system that deviate, that take people away from the criminal justice system so they don't encounter it in the first place. And a big challenge to making changes is that we just don't know enough. We don't know enough about cost recoupment and reallocation to make the claims that the system is ineffective. But at least from my research so far, I found that it is ineffective, it's inefficient in punishment, and it's unethical in its nature and treatment of poor people. So I left a little bit of time. Thank you so much for your patience and listening, and I'd love to see any questions that you might have.
Okay, thank you so much, Professor Harris. We had a quick clarifying question as we transition to Q&A here. Someone asked if that 1 in 12 statistic for the incarceration of black men, that's a national statistic, right?
That's a national statistic, yes.
Okay. So our second question, we have someone who works on TANF programs, and he's found that among a number of the caseworkers that he is in contact with, a lot of them feel that sometimes these sanctions, these monetary sanctions, are sometimes effective ways to encourage compliance, but he's doubtful. Is there a sense of what sort of levels of is there a small level, or is there a cutoff where maybe there is any sort of effectiveness at all in these sorts of fees?
I haven't. There is a scholar, Barry Ruback, R-U-B-A-C-K, has looked at the effectiveness of payments in, I want to say Philadelphia, and in terms of looking at payments versus compliance with probation. And sort of the obvious finding is you make payments, you're in compliance with probation. But I'm not aware of research that yet looks at recidivism. It's something we've been trying to do with the automated data that we have. It's just been very problematic. Within the current research project that we've been discussing some of the findings, and then also with some of the interviews I did for my book project, there were people who say, I have this one woman I interviewed, and she said, yeah, I can go back and turn a trick. I can go back and, sell my body to make some money on the street to pay my fine and fee, but I don't think that's something that the state wants me to do. So people have hinted at recidivism or re-engaging in criminal offending to pay their fines and fees in that way, but I haven't seen research yet on creating compliance. If that increases compliance. I mean, I think if people have the money, they'll pay. If they don't, it doesn't impact whether or not they still want to stay on the right side of the law.
Okay. We have another question about the sort of the legality or the constitutionality of requiring parents to pay fines or fees for rehabilitative services for their children or for youth. Do we know anything about that?
I've looked at the state statute in Washington State, and parents can be found able to pay for their child's sentence. There was one case, and I'm blanking on the name of it. I can look it up, the name of the case, but where a young girl was charged with, I think she threw a rock through a window, and she and her mom were making regular monthly payments, but the mom lost her job. And they extended probation on her, and then they finally sentenced her to juvenile hall to serve a number of days for not making payments, and it was found that that was constitutional because she should have been in compliance with her court sentence. So the language of the court is really interesting, is that there's no real discussion in the courtroom about ability to pay and about why people aren't in compliance. It's just deemed you're not in compliance, you go to court. Even though, I've literally seen defendants beg judges saying, look, I have no money. But there's no room for that discussion or assessment in current state statute.
Okay. We have a question from Mike, who's asking if there are sort of international examples of other countries that maybe have successful alternatives to this, of not using monetary sanctions for these kinds of things. If they, do you have anything there?
Right. So I have examples in my book where I talk about the use of day fines in other states, I mean in other countries, where, again, they use the fine in lieu of incarceration, so people aren't paying in addition to going to jail and prison, but it's based on what the defendant has the ability to make payment. So it's much more sort of thoughtful about, will this person ever be able to fulfill this punishment if we give it to them?
Okay. So just in terms of local examples, or examples from the U.S. I mean, are there specific jurisdictions, other places that have also found good alternatives to this, or that seem to be operating in a way that's more successful?
Yeah, people ask this question, and I haven't found it yet. We're looking at 8 states, and we haven't done the full ethnography yet of different courthouses, so I'm not sure. And, in one of my counties in Washington State that I looked at would only incarcerate people for non-payment of restitution if there was a sign that they had the ability to pay. So if they came to court with a private attorney, the judge, and they weren't paying restitution, the judge would say, well, you're paying a private attorney, you have money to pay restitution, you're going to jail. So that county is looked at as a good, positive county where they're not just incarcerating for non-payment of fees, but it's focused specifically on the victim and restitution. That's the best example I can come up with right now. I'm hoping when we get into the counties and this 5-year study that we'll see examples of sort of, if you will, good counties, good practices that protect the rights of poor people.
Okay. I know the data is limited on this, but do you have any sense of sort of geographic variation in these practices? So whether, rural, urban, or different parts of the country, is there any sort of, broad brush statement you can make about that?
That's a super good question, and that's, again, something we're looking at. I mean, our states that I selected are pretty representative of we selected 3, within each state we selected 3 counties and 3 municipalities, and we did that based on suburban and urban jurisdictions, and so we're going to be able to get at that. We just need another year or 2 to do the data collection to figure that out. But it's interesting to talk about like Missouri and what we know so far with the DOJ report on Ferguson and the Art City Public Defender report on St. Louis County, and the numbers of municipalities are outrageous, and it makes you question. I mean, some people would have to drive through 6 cities to get to work, right? And that's 6 cities sort of ready to try and convict you for certain fines and fees to sustain their municipality. So there is a story there, I think, that we're still thinking through about particularly suburban or jurisdictions that really rely on the fines and fees to maintain their real small municipality and their small police force. There is a story there. I don't have enough data yet to tease it out.
We have a question on the hard labor component. So for failure to pay fines or fees, one, how well that's sort of defined as reasonable. But a second question of is there sort of like a monetary? I mean, do they receive payment for that hard labor to pay these fines and fees? Or is it just strictly?
In some jurisdictions, you will receive payment, maybe $1.25 per hour. So you receive a very minimum payment for labor. It's important to note that when you have an inmate account, it can be charged monthly or deducted monthly, your payments towards your legal financial obligations. So that $1.25 that you work per hour goes towards your inmate account, but monthly, what's deducted, there's a percentage deducted from that to go towards your legal financial obligations. In other jurisdictions, you aren't paid for your labor. That's part of your sentence, and we know that that's legal. You can be that slavery was abolished only for those not convicted of offenses. That people convicted of offenses can be forced to do labor.
So we only have time for one more question, unfortunately, and so I'm going to ask about incarceration for non-payment of child support. Do you cover that much in your work?
I don't, and I have so many people that raise this question that this is an additional bucket of court-imposed costs to individuals. I haven't personally researched this. I've talked with some other scholars that are interested in going. If graduate students, if there are any graduate students on the line, it would be great question to pursue is what's the relationship between child support payments and how frequently are people being incarcerated? It's a really interesting open question right now, empirical question for analysis.
Okay, well, that brings us to the end of our time for today, unfortunately. And thanks so much, Professor Harris, for sharing your work with us and all of your research today. And I really appreciate everyone that joined us for today's webinar. As a reminder, we will be posting a recording of this webinar on the IRP website and on our YouTube channel within a couple of days, so please do look for that. And also, I want to invite everyone to our upcoming webinars for the remainder of 2017. We've got a great lineup. Our next one is going to be on September 6th, and that's with Amy Kind, and she'll be talking about using neighborhood socioeconomic data to improve health outcomes, public health outcomes. So we're going to start registration for that, open that up towards the end of the month of July here, so keep an eye out for that email. But again, thank you, Professor Harris, and thanks everyone for joining us today.
Thank you so much. I appreciate your attention.